employee and employer side. I invite Honorable President of Income Tax Bar Association, Sri Mudangbi Vakil, for his brief speech.
Thank you, Karthike bhai. President of AGFTC, Karthike Shah, other office bearers on the dais, on virtual dais, today's learned faculty Vatsal bhai Parikh, Advocate Gujarat High Court, members attending this webinar, ladies and gentlemen. On behalf of Income Tax Bar Association, I welcome all the participants and in particular today's faculty Vatsal bhai Parikh in this webinar for and a very important subject, labor law and its implication on day-to-day affair. Of course, we are practicing on income tax side, but our major client are also falls under this today's topic. So for this, we are required to update our knowledge on this important subject. And I must appreciate to take the initiative by President of AGFTC to organize this webinar on this very important subject. With this, I once again welcome one and all and today's faculty Vatsal bhai Parikh. Thank you very much.
Thank you, Mrudang bhai. Friends, Advocate Vatsal Parikh is a renowned lawyer in Gujarat High Court, and he is practicing in labor laws. So it is really fortunate that we are having him, and we will learn nitty-gritties of labor laws. And friends, though we are doing practicing taxation, but we must be aware of allied laws, because in day-to-day life, we need to advise our clients on these laws also. I request Honorable Treasurer of All Gujarat Federation of Tax Consultants, Sri Shivam Bhai Bhavsar, to please introduce today's honorable speaker.
Thank you, Karthik bhai. Good evening, everyone. Today's speaker, Advocate Vatsal Parikh, going to highlight a very unique topic, that is overview of labor law and its implication in day-to-day affairs. Advocate Vatsal Parikh, having experience in the field of various laws before the High Court of Gujarat, Labor Court, EPFO Tribunal, ESIC Tribunal, Debt Recovery Tribunal, and other government authorities. He is also working as a visiting faculty, worked as a visiting faculty in the Khyati College of Law, and he is also invited as a judge in various law competition in GLS Law College of Gujarat. Thank you.
Thank you, Shivam Bhai. Vatsal Bhai, please enlighten us on labor laws so that we can advise our clients in a better way. Welcome, Vatsal Bhai.
Yes, first of all, I would like to thank you, each and everyone, President Karthike Shah sir, Jinal Shah sir, Dhruvid Mehta sir, Nodang Vakil sir, Sridhar Shah sir, and AGFTC Income Tax Bar Association. I am very privileged to have this guest lecture on overview of labor laws and applications on day-to-day affairs. I once again thank each and everyone, as well as the office bearers of the AGFTC as well as Income Tax Bar Association. With this, I would like to start with the topic, if it is permitted and if everything is fine. Now, today I will be sharing view on labor laws and its implication on day-to-day affair. Now, how many laws are there in labor laws? Here, it has been divided on various aspects. That is, laws on wages, in which payment of wages is included, minimum wages is included, payment of bonus is included, Equal Remuneration Act is included. Here, payment of wages, see, as we all know, that payment of wages would include payment that is to be made to the employees or the workmen. Now, payment of wages is basically for what time the payment is to be done, how the payment is to be done, in what manner is to be done, and what if the payment is not done. So everything will be included in this payment of wages. I would not go in each and every act, but the overview I will be definitely going in conditions. The Factories Act, wherein the wherein everything regarding the factory, as in the health, the safety, everything is mentioned in the Factory Act. What should be the standards? What should be the safety measures that is to be taken care by the company, etc. has been mentioned in the Factory Act. The Mines Act, the Motor Transport Workers Act, the Contract Labor Regulation and Act, the Shop and Establishment Acts enacted by various state governments, and the Child Labor Prohibition Regulation Act. The other thing is laws on employment and training, wherein the Employment Exchanges, Compulsory Notification of Vacancies Act is there. The Apprentice Act is there. Laws on labor welfare funds. The Gujarat Labor Welfare Act is there. The MICA Mines Labor Welfare Fund Act 1946 is there. Iron Ore Mines, Manganese Ore Mines, and Chrome Ore Mines Labor Welfare Fund Act is there. The BD Worker Welfare Fund Act is there. Now, laws on social security. First is the Employees Compensation Act, wherein the compensation in regards to any of the fatal accidents or minor accidents is done. In that Employee Compensation Act, everything covers how much compensation to be paid when there is an accident or where there is an minor injury. Second is Employee State Insurance Act, wherein ESI Act, which states that any benefit given to any of the employee who is earning less than 21,000 of gross wages is covered under this act. So again, here the benefits with related to you say hospitalization as well as benefit related to funeral expenses, everything is provided in this. And Employees Provident Fund Miscellaneous Provisions Act. This is a very important act, as in almost a person would be having the total savings of his entire life in this account. So when a person is retired, he would be getting PF account, PF amount, as well as the pension from that. So again, it's a very important act. The Maternity Benefit Act. The Maternity Benefit Act is for the mothers, lactating, for the mothers who are pregnant, and the benefits that they get, as in the leave benefits, as well as the medical benefits, etc. Now, laws on industrial relation. The Trade Unions Act, wherein trade unions are recognized trade unions are there. How to register trade unions, everything is mentioned in that act. Industrial Employment Standing Orders Act, that is related to the factory who is having more than 100 workers. Then Industrial Dispute Act is there. Gujarat Industrial Relation Act is there. Now, how would we like to go to Payment of Wages Act in a nutshell? So what is the object of that? Now, the object of the act is to regulate the payment of wages of certain class of employed persons. Where it is applicable. Now, it will be applicable to factory, including establishments and industrial establishment, tramway services, motor transport, service engaged in carrying passengers or goods, or both the way, road for hire or reward, air transport service, dock, wharf or jetty, inland vessels, mechanically propelled, mine, quarry, oil field, plantation, workshops, or other establishment, etc. Now, let us go to next slide. Coverage of the employees. So a person who is earning 24,000 up to 24,000 would be covered under this act. Now, as you all know, that now 4 codes would be coming up. So in that, the coverage as such is not decided, but the definition of the employee has been widened up, as in all the employees, as in a person who is in managerial capacity, a person who is already working in a in a short, we can say that blue collared as well as blue collared as well as white collared jobs. So every person would be benefiting with this particular new enactment, that is code on wages. Now, so what benefits would be there? Right now, presently, what is happening is a person who is a workman can get benefits under this act. As in, if a person is not getting any salary or any wages, then he can go to the labor commissioner and ask for that particular the amount that has not been got as a wages. So he would be getting wages as per that act. Now, if a person who is a manager would not be getting benefit under this act because he is not covered under this act. So now, when the code on wages would be implicated, all the codes will be implicated, then at that time, this person, that is a manager, as well as every other person, would be benefited in this act. But what is the time of payment of wages. So where there are 1,000 or less employees working in an industry, then the payment of the wages is to be done by the 7th of the following month. And when it is 1,000 or more, then it should be done before 10th. Now, deduction made from wages. See, when wages is given, so there are some deductions we make, as in to adjust the amount, as in sometimes due to some, you can say, some penalties imposed on the employee due to some mischief done, or any kind of warning is issued, for that penalty is imposed. So that deduction, what deductions can be made? I'll read section 7. Deductions such as fine, deduction for amenities and service supplied by the employer, advances paid, overpayment of wages, loan granted for house building or other purposes, income tax payable in pursuance of the order of the court, PF contributions, cooperative society premium for life insurance, contribution to any fund constituted by employer or trade unit, recovery of losses, PSA contribution. So these are the deductions can be made. Apart from this, no deductions can be made. As in, if I want to deduct an amount for fine, then I can deduct it, but that is to be used in welfare activities, and that cannot be used in any other activity. Now, payment of wages act. So what, see, I'll give you an example now. What if a person who has filled up in tender with a government authority, now that person or that company would be paying wages to their employees employed by them. Now, what if that wages are not paid? So the principal employer will have to pay the total wages in case if the contractor is failed to pay the amount. Right now, see here, what we have to remember is ultimately the responsibility will be of principal employer. So if principal employer, being principal employer, we are not taking care of payment of wages, then ultimately we will have to deduct it from the contractor by way of forfeiting the security deposits or any other amount that is with us, that is retention amount or anything. So payment of wages with respect to contractor is to be monitored by the principal employer. Now, in how much time an employee can make application for payment of wages? So, application for payment of wages can be made within 12 months. If it is beyond 12 months, then there should be an reasonable cause, a reasonable explanation given for the delay. If it is satisfied, the court will definitely allow it beyond 12 months also. Now, Minimum Wages Act. Now, as you all are aware that recently the minimum wages has been revised. So now I will only go for a skilled employee in category A. So in category A, right now the minimum wages is 9,786 amount. So a person cannot be given less than minimum wage. The practical difficulty what is happening right now is, now because of this higher side wages, what employers are doing, they are not showing them on books. They are showing them by paying. They are paying them cash, and they are not showing it on the accounts. Now, because of it, many losses are there. As in, which kind of loss? First loss would be if a person meets with an accident. Then what? So, if a person is not shown in the books of account, then it would be very difficult for him to justify that the person who is met with an accident is the employee. And moreover, the benefits that the acts which I'm going to discuss it later, the benefits of ESI or employees compensation would be at very risk if it is not shown, if the employee is not shown in the books of account. So now other thing what happens is, a person when wants to employ someone, but the person is ready to come in 8,000 per month job, and whereas we have to pay 9,786 or 83, I may stand corrected. So that amount we have to pay. So now what we will have to do is, we will have to adjust the amount. As in, we have to maintain such records so that we can say that the amount of minimum wages is already paid. So that adjustment is also not legal as such, but yes, we have to do just because we want to meet the ends of the company's criteria. Now, Section 3, fixation of minimum wage. Who generally fixes the minimum wages? The appropriate government fixes the minimum wages, and which is revised every 6 months. Payment of minimum rate of wages. Employer to pay every employee engaged in scheduled employment at a rate not less than minimum rate of wages as fixed by the notification by not making deduction other than prescribed. So the practical aspect right now, what is happening is what employers do. Employers would hire a person on the minimum wages, but he will not pay it. He would be paying, let's say, for example, 8,000 rupees. Now the remaining amount will be adjusted by showing it the other deduction amount. So whether that is permissible? No, it is not permissible. So for that, justification is to be given where the amount has been deducted and whether that deduction is as per law or not. And again, previously I said that deduction which has been made cannot be utilized in any other fund. It has to be utilized only in the welfare fund. Overtime. So now a person, actually the current scenario is a person is engaged for 8 hours, but he is made to work for 12 hours. The books of account shows, or rather the register is shown that he is only working for 8 hours. Now, what about the excess amount? If a person is working for more than 8 hours, then he has to be paid 2 times of wages. Now that wages would be the minimum, the gross amount. As such, as per the act, the minimum wages, the overtime wages is only for basic and DA. But what practical thing is to pay the amount single time of the gross amount, so that basic and DA would be doubleized by itself. Now, which are the which are the registers and records to be maintained? Registers of fines is to be maintained, wherein fines which are imposed to the employees due to any of misconduct or say absence or unauthorized absence, etc. Annual return form register is to be maintained. Annual returns are to be filed before 15 January. Register of overtime is to be maintained. Now, in this also, register of overtime, no one is maintaining register of overtime. What they right now do is they will directly prepare an application, and salary register whereby overtime would be the amount of overtime or the time of overtime is mentioned. So again, that is wrong, but this is the practical approach which is right now followed. Register of wages, representation of register for 3 years. So a person is required to maintain register for 3 years. Till then, if, for example, if any matter is filed before any authority, then if you are saying that I have not maintained the register beyond 3 years and henceforth I am not able to produce the same, then that will be a valid thing as per the act. But as per Income Tax Act, we are required to, I may stand corrected, but as per Income Tax Act, we are required to maintain register for 7 years. Now, claims by employees. The claim here should be filed within 6 months and not beyond that. So if a person is not getting enough wages, that is a person is getting, say for example, 8,000 wages, then the excess amount, the difference amount, that is the current minimum wages minus the given wages, is to be claimed within 6 months, and compensation up to 10 times is given. Now, important points: revision and rate change every 6 months. Now, in one of my contractors' company, what had happened was the person is a contractor. He had applied for a tender in one of the government companies by quoting rate in the tender condition. Now, he had quoted the rate as per the normal revision which is taken place every 6 months. Now, all of a sudden in 2017, in central minimum wages, there was a rise of almost 83 to 86%. So now, what will be the effect? For example, if I have given quotation of a person working for 8 hours for almost, you can say, 400 rupees. And now, if that is changed to 800, almost you can say 750 or 650, then what about the difference amount? If the amount has been quoted in the tender, then that will not be changed, right? So escalation clause is to be there in the tender condition. If it is not there, then representation is to be made to the government authority or the the entity which is issuing the tender, that there should be some escalation clause. Now, in my case, what happened was the increase was almost 83 to 86%. The principal employer, that is the government entity, declined that we will not be giving any of the excess amount. Now, what will be the issue? What will be the scenario right now? The employees are to be paid within 7th of every month of the following month. If they are not paid, they will make a complaint against before the ALC, that is Assistant Labor Commissioner. If the amount is not paid within the time, we'll have to pay the damages as well as the compensation to it, and we are also attributable to the fine. Now, what was done at that time was, as per the Contract Labor Act, that I will be coming later on a later stage, when the contractor fails, the principal employee is liable to pay the amount. So what the contractor did was, he gave an application to ALC showing the section of this act stating that when contractor fails, it is the principal employer who has to pay the amount. So he was saved by that. But the amount which I said, that is the retention amount or security deposit, was forfeited by the government entity. Now, what will be the way out? He'll have to file an arbitration if it is provided in that agreement, that is tender condition, and thereafter he will have to fight for it. Again, arbitration, as you all know, is very expensive. So again, he was not able to cope up with it. Now, what is the last option remaining? If he is not going for arbitration, he'll have to bear the cost. Right. So for that, a very important point is, when our client, that is our contractor, is applying for any tender, the first thing we have to say is that, remember, for escalation of price, remember whether there is a clause stating that escalation is there or not. If there is no clause, then representation is to be made. And if representation is not made, then this might have serious problems thereafter. Now, payment of bonus act. Bonus is to be given to each and every person, but here the cap is 21,000. So a person who is earning less than 21,000 is liable to get bonus. But where the bonus will apply? When an entity or any of the office where 10 or more employees are employed, the bonus act will be governed. Now, what if there is a company which is a startup? So when a company is a startup, within 5 years, if no profit is made by that company, they are exempted from paying bonus. And from the 6th year, or from the day on which the profit is made, they have to pay the bonus. What is the component of bonus? Salary or wages includes dearness allowance, but not other allowance. For example, overtime, HRA, incentive, or commission. Now, again, I would like to quote here one thing is, as such, there is a CTC structure, that is cost to company. Now, in that, everything is included, as in the allowances. For example, a person who is earning almost, you can say 6 lakhs per annum, then his take away home would be the less amount. That is, and moreover, to avoid taxation expenses as well as other expenses, what the company will do, it will bifurcate the gross amount into basic components, as in basic, DA, HRA, and other allowances. So if this kind of allowances, if a person is to be given this allowances, then the bonus is to be given on basic and DA, not on other allowances as per the act. Now, as per current situation, what company employer do is, the employer always calculates the bonus on the total amount, that is gross amount, so as to avoid any further consequences with regards to non-payment of bonus. They don't want any, we can say that any litigations going on for so-and-so non-payment of bonus. Now, what Act says is, how much amount is to be paid? Amount, minimum wages, so the bonus is to be calculated on the minimum wages. So now, if a person is earning 21,000, so the direct calculation is 21,000 is to be paid. So for 12 months, and over and about 12 months, 1 month bonus is to be paid in extra. That is 8.33%. Now the Act says 8.33% or 20%. it is upon the company. If the company is see, there is a form A and form B which is to be maintained, in which it specifies that there is a profit made by the company, then that profit is to be shared to the employees or the workmen as an allocable surplus. Now, what right now is done is the third part, that is the 13th part is given as bonus. Actually, how bonus is to be calculated? As per law, the bonus is to be calculated on the minimum wages. So, for example, if a person is earning basic of 15,000 and in total 21,000, then he will be covered under bonus act. What amount he would be getting for bonus? So we have to calculate it on the basis of the minimum wage is prevailing and not 21,000. But this practice is as such not accepted, and it is not going on in the present scenario. Now, eligibility of bonus. A person who has worked for 30 working days in a year only would be eligible for bonus. So a person who has joined the job and has left before 30 days, he would not be entitled for any bonus. Now, wage and salary living. As I earlier mentioned, the wage, ceiling is 21,000 per month. However, for calculation purpose, 7,000 per month or minimum wages in scheduled employment, whichever is higher. So I told that when minimum wages is higher than 7,000, the actual calculation is to be done on minimum wages. What is the time limit for payment of bonus? So the payment of bonus is to be made within 8 months. So bonus of, for example, 2021 is to be paid in 21 within 8 months from Diwali. Because in general, every companies will calculate bonus and will give bonus in Diwali. Now we will go to Factories Act. What covers under the Factory Act? Now applicability, where 10 or more persons are employed with the aid of the power, are that premise would be applicable under the Factories Act, but wherein manufacturing process has been carried out. If no manufacturing process is carried out, then it will not be under the Factories Act. Now, for that, approval and license and registration fees are to be done. In one of the cases, what had happened was there is one premise of GIDC. Now, in that, 3 factories are going on. Now, as per Factories Act, plans are to be passed, the exact map is to be given, everything is to be done. Now, if a person is running 3 factories, and if one wants to add that factory, one more factory, then revised license is to be taken in every company, in every factory. So in a single premise, when 3 factories are running, 4th factory is to be incorporated, then licenses of revision in 3 factories as well as the new license for 4th factory is to be taken. What generally is done is only license of the new factory is taken by giving by showing the maps which are not as per actual terms and conditions or actual scenario, and by this way they are taking licenses which is actually not valid and which should not be done, because when this kind of license when taken, and if there are any breaches of Factory Act, then the factory inspector would definitely file any prosecution against the company, against the director as well as the manager. So this is to be avoided. Now, employers to ensure health of workers pertaining to cleanliness, disposal of waste, ventilation and temperature, dust and fume, overcrowding, artificial humidation, lighting, drinking water, latrines and urinals, spittoons, etc. Now, a company has also to take care that even lime wash is to be done every 6 months. So precise care is to be taken for the safety of the workers and for the health of the workers. Now, safety measures. What are the safety measures? Now, fencing of machinery, work on or near machinery in motion, employment of young persons on dangerous machine, striking gear and device of cutting of power, self-acting machines, casing of new machinery, prohibition of employment of women and children near cotton openers, hoist and lifts, lifting machines, chains, ropes, and lifting tackles, revolving machinery, pressure plant, floor stairs, and means of access. So, what is to be done is when a factory is incorporated or when a factory is established, These are the safety measures for which every safety, these are to be certified safety officers, and thereafter only the factories can be worked or can commence manufacturing. Now, in one of the cases, what had happened was there was a underground water tank wherein the water was almost you can say 30 degrees 30 to 35 degree Celsius. So that was hot water. What had happened was there was no cover made. Now, because of no cover, only one wooden sheet was placed on it. So what happened was when the employee was traveling from there, the employee fell in. Now, once the employee fallen, now everything will come into play. That is, Factory Act will come into play, ESI Act will come into play, Employees Compensation Act will come into play. As in, he will have to be provided with adequate medical facilities. He will have to be provided with adequate compensation with regards to injury. In that case, what had happened was he died. Now the company came to know afterwards, after the search was carried out, that where is that person? And when the person was found in the tank, immediately the police officers were called, the fire brigade was called, ambulance was called. But one thing was not, one thing they failed was they failed to inform factory inspector. They ought to have informed factory inspector within 24 hours. That was not done, because of which the factory inspector had initiated a case against them for prosecution of non fulfilling of the terms and conditions of the act. So for that, again, the penalty is there, imprisonment is also there. So it depends on the court what kind of punishment they would be giving. Now, in that case, again, I will come to the next. When I come to the next act, I will definitely guide you in detail that how, in that case, we had taken benefit from ESIC. Working hours spread over time and adult and women workers. Now, a person cannot work more than 48 hours in a week. Now, and daily hours, 9 hours, not more than that. He is to means he should work. Now we are making them work for 12 hours and we are showing only 8 hours. This is the real scenario of the present situation, present companies who are working, who are employing the workers. Now, spread over should not be more than 10 and a half hours. Overlapping of shifts are prohibited. Extra wages for overtime, double the normal rate of wages are to be given. Nothing is right now seen, and henceforth, what is happening is the inspection level are increasing, because of which inspections by the factory inspector with regards to the time of working, whether the overtime is paid, whether high cards are given, whether other terms and conditions are followed, whether rules and regulations of safety measures are followed. Everything is right now in a great pace, just because no company is following. No, I would not say no company, but very minimum company is following this act, these provisions. Now, annual leave with wages. A worker having worked for 240 days, at the rate 1 day for every 20 days, and for a child 15 days is to be calculated. So, a person who has worked for more than 240 days, he will have to, he would be entitled to get one day of leave with wages when he has completed 20 days of work. And in case of a child, when he has completed 15 days, he will be getting 1 day. And the accumulation of that leave can be maximum 30 days and not more than that. If more than 30 days are accumulated, then that will be lapse. So, for example, if 30, say for example, a person is having 63 at the end of the year, then only 30 would be carry forward. The rest 33 would be excluded, and that will be waived off. Now, important point. As I already discussed, that factory license is a very important thing, without which no factory is to be, no manufacturing process is to be commenced. One of my client had recently started manufacturing process without taking a factory license. I would not like to name my client, but prosecution was going on, and the judge was like, he would definitely send him to imprisonment. So these things are to be taken care of. Primary, without factory act license, no manufacturing process is to be done. That factory is not to be commenced. I also suggested that intimation regarding accident resulting into death is to be done within 24 days. So if that is not done, what are the consequences? I've also explained that. Now we will jump to Contract Labor Regulation and Abolition Act. What is the object of that? To regulate the employment of contract labor in certain establishment and to provide for its abolition in certain circumstances and for matters connected therewith. Applicability. So initially, what the 20 a person when a establishment is employing more than 20% was the act was applicable to that. But recently in the COVID times, that is in last year into 2020, that the 20 the number was the 20 digit was amended, and now 50 workers, if you're working in an establishment, more than 50 workers, then only the registration is to be done by the establishment. In this contract labor, registration is to be done by two persons, that is two entities, that is one is the principal employer and second is the contractor. So if a person is right now engaging more than 50 employees on contract basis, not regular basis, on contract basis, then they are required to take license under the Contract Labor Regulation and Abolition Act. And subsequently, a contractor who employs more than 50 is required to be taken take this license. So, what if a contractor who is engaged into this activity of supplying, for say, for example, security? So, what if that particular the contractor is employing only 15 employees or 15 security guards, then he is not required to take any registration, despite of principal employer has taken the registration. Now, what is the liability of principal employer? See, to ensure provision of canteen, restroom, sufficient supply of drinking water, latrines and urinals, washing facilities, etc. Principal employer is also entitled to recover from the contractor for providing such amenities or to make deduction from amount payable. Uh, what happens is a person in the sense a workman who is employed by the contractor as such is not given the rights of similar to the workman employed by the employer, that is principal employer. So this act nullifies that. So in comparison to the other workers, that is the employees employed by the principal employers, they are also required to get facilities of canteen, restroom, etc. Now, what are the responsibility of contractor of payment of wages? To pay timely and to ensure the disbursement of wages in presence of the authorized representative of the principal employer. The current scenario right now, what is happening or what is prevailing is no principal employer or no person from principal employer is remaining present at the time of disbursement of wages by the contractor. Yes, in a company where more than 500 or which is an establishment or which is an established company, or you can say which is a very good company, does this follows this particular provision. But small companies, wherein you can say 50 or 20 employees are there, or you can say 100 employees are there, they are not seeing to it that the contractors are paying the wages. Now, what contractors are doing? The practical aspect right now is the contractors are actually not paying the total amount to the employees or to the workmen. What they are doing is they are paying that amount to some of their relatives, or their name would be shown. The work would be done by the X X person, whereas the payment would be done to the Y person, and the Y person would be the relative of the contractor. So to avoid this, uh, person authorized representative from principal employer is to be there. Now, why these things are done? See, contractor, it is but obvious that they would be saving money, or to make profit, they would not be giving the total amount as wages. They will be collecting 9,000, say for example 9,000 from the principal employer, and they will be only paying 8,000 or say 7,000 to the employees. But even sometimes 7,000 is also not paid. They would be paying 5,000, 4,000 only. His name will not be shown in the books of account, or his name will not form the part of the salary register. The person, the relative of the contractor name would be shown in the register, and he would be paid the amount. Whereas the sign of the particular employee would be taken in a plain paper, whereby it would be shown that the amount is paid to them, so that in case they make any representation that they would not receive the amount, they can show it to it. However, when there is no name shown in the salary register, they cannot take benefit of such claim that the amount has been paid. Moreover, if a person is not shown in the books of account or salary register or muster roll, then uh, what happens is, for example, if a contractor worker has met with an accident, that in that case, what will be the issue? What will be the scenario? The principal employer will have to face the benefits or the consequences. The benefits with regards to medical benefits, with regards to compensation, would have to be paid by the principal employer, since contractor has not paid. So for this also, principal employer has to see whether the amount is actually paid to the worker of the contractor or not. Responsibility of contractor for payment of wages. What is the responsibility to pay timely and sorry, this has been done. Rate of wages not less than minimum wages. As I already said, the current practice by the contractor is by not giving the minimum wage and showing the relative's name and adjusting vice versa. So that is to be checked by the principal employer. So if our clients are principal employers, this is to be first condition that the contractor, if they are paying the amount, it should be paid in front of us, in front of the authorized representative. Now we'll move to Employees Compensation Act. Now this act provides for benefits in case of any accident takes place or in case of any death. So if a person, say for example, a workman who is not working with the particular establishment, but he has worked for a temporary period. For example, for we can say that a particular company wants to make a shed, construction shed. They want to construct a shed. Now, in that, the construction is given. The construction work is to be given to the contractor. That contractor would be employing the workman. Now, that workman would not be covered under our employment. So, what will happen is that person will have to take, the contractor would have to take workman compensation policy. In other words, it is said WC policy. So if a person has not taken that policy, what will happen? That the total consequences will have to be borne by the principal employer. Now, coverage of workmen. Here, irrespective of the salaries, the status, every workers are covered under this act. So, say for example, if a person working as a manager meets with an accident while in terms of employment, then he's also covered under this act, and he can take benefit under this act. He can claim compensation. He can claim damages also from the company. Now, Section 3, employees' liability to pay the compensation on death or personal injury resulting into total or partial disablement or occupational disease caused to the workman arising out of and during the course of employment. See, here a person is to be paid compensation only when the accident has arisen out of the employment. So, for example, say if a person who is working as a sales representative has gone for in the field work, and he is into the time, as in the what you say, let's say that his time commences from 7 to evening 7. So if a person in between goes out and if he meets with is meeting with an accident, but the accident is not taking place in the premises of the employer, so whether he would be getting this benefit or not? Yes, if the salesperson is acting with respect to the terms, with respect to the profile given to him, then he will have to, the employer will have to give the compensation in case of the accident. Now, deposit of compensation. So compensation, if compensation is occurred, and then that is to be deposited within the commissioner within 1 month. And if that is not deposited, then they may file the case, and accordingly the interest is to be given. Interest is almost calculated on 12% per annum. Again, prosecution will also be there if compensation is not submitted. Now, Employee State Insurance Act. This is an almost identical benefit giving act with respect to employees compensation act. But in this, your ESI provides hospitals also. So a person who is a member of the ESI, that is a person who is earning less than 21,000 rupees, would be covered under this ESI act. So 21,000 gross amount, I would say. So a person who is earning less than 21,000 and is paying contribution towards the ESI, then he will be covered under this act. So for example, see what are the benefits? I would just give an example regarding the benefits. Say a person is not well. What he'll have to do is, if he is a member of ESI, he'll have to go to the hospital dispensary, which of the ESIC, and he has to take medical guidance of the doctor present over there. If the doctor there gives a certificate that he is not fit for work, then what we'll have to do is he have to give that certificate to the ESI office, and thereafter, for the days unfit is given, he'll be getting the salary from ESIC. The employer will not have to pay that amount for the work for which he is not performed. So it will be beneficial to the employees. I would like to mention here whether a person earning more than 21,000 is covered under ESIC, then the answer is no. So if a person is earning more than 21,000, he'll have to, the WC policies will have to be taken for him. That is again as per the Employees Compensation Act. He would not be covered under ESIC Act. But what if a person earning 21,000, for example, a person is earning 21,000, exact 21,000 in January, but the amount has been increased, and his amount the salary has been revised and increment has been given, and the person is now earning 22,000 in February. So a person, when he is earning 20,000 in February, he is not excluded from February itself. He has to complete the contribution period. That will come in the next slide. I will show you. So a person will also be benefited, will get benefits till the next contribution period is over. Yes, before I further go to it, a person when a company is employing more than 10 employees, ESI would be applicable. So if a person, if a company is not, for example, say employing 10, but if they are employing, say for example 8 employees, then whether this act will be applicable? No, this act will not be applicable, but they can take by showing 2 employees for a day and thereafter kicking them off. So see, what my suggestion, being a labor law consultant as well as labor law advocate, would be ESI would be beneficial to each and every employer as well as employee. How it will be beneficial? I would like to give an example. Say, for example, a person has died in the course of employment. Now, if that person is not covered under ESIC, then as per Employees Compensation Act, he'll have to be paid compensation by the employer. That compensation may come up to say nearly about 10 lakhs, 8 lakhs, 3 lakhs, depends on the schedule provided in the act. There is a calculation also provided in the act according to which calculation is to be made. But say, for example, a person, if he has died, I would take to the example that in one of my company where the person fell off from that, fell in the underground tank and had died. In that, what if ESI benefit was not given? Then in that, as per his age, as per the factor given in the Act of Employees Compensation Act, he'll have to, the employer would have to pay almost 10 lakh on odd amount. But because of ESI, what had happened was the ESI contribution was paid with respect to the state employee. So he'll just have to fill up a form of an accident in the ESI portal. After filling that particular form, verification would be done, and thereafter he would be getting compensation. He would be getting pension. The legal heirs would be getting the pension as well. The deceased would also be getting funeral expenses and everything. Now, in terms of Employee Compensation Act, he will be giving 10 lakh rupees, whereas here he would, as he was contributing towards ESIC monthly basis, he is not having any major expense. So this is the power of ESIC. So the company would not have to spend more if ESIC registration is taken by them, and they are covering the employees less than 21,000 with ESIC. What is the rate of contribution of the wages? So as I said, 21,000 is the limit wage ceiling. So a person earning 21,000 or less are covered under ESIC. So say, for example, if a person is earning 20,000, then contribution employers have to pay 3.75% contribution, whereas employee will have to pay 75%, 0.75% contribution towards the ESIC, and it has to be deposited or remitted, in other words, within the next 15th of the next month. Here, this slide shows benefits to the employees under the Act. Section 46 of the Act envisages following six social security. Medical benefit is that, as in a person, if a person wants to take medical benefit with regards to, say, for example, operation of knee replacement, then yes, as per if he is a member of this ESIC, then he would be entitled for such replacement, knee replacement in ESIC hospital or other hospital as preferred by the ESIC, or any letter issued by the ESIC to go to such and such private hospital. Many private hospitals such as say, Shelby, other hospital is I'm not sure, but I guess Zydus was also there. So these are the hospitals in which the services are extended. So if a person wants to take this kind of benefit, then the employee would not have to pay anything. He just have to go to the dispensary, ESI dispensary or ESI hospital, and tell the difficulty what he is facing. And after every expense would be made by the ESIC. Sickness benefit. What is sickness benefit? So as I explained, if a person is not well, he goes to the dispensary, and unfit certificate is issued by the doctor who is sitting there. Then the 75% of the wages he is earning would be provided by the ESIC. So this is the sickness benefit. Extended sickness benefit is the enhanced sickness benefits. If the sickness is extended, then for that also some provision, some amount is given to the workman. Maternity benefit is given. Disablement benefit is given. See, if a person is suffering from temporary disablement, then the criteria which has been mentioned in the Act, that compensation would be given, or that amount would be given. In case of permanent disability, he would be getting pension. He would be getting the salary as well. And other is dependent benefit. So, in one of the case, what had happened was a company had hired a person. His salary was say about 15 to 20,000, in between to 15 to 20,000. Now that person expired. That person was almost age of, if I remember, he was almost 32 something. The dependent the benefit which I'm talking about, the legal heir, that is the wife as well as children, got almost pension of 21,000 to the wife and half the pension to the children. So I would say કે ગુજરાતીમાં કહીએ તો કે જો જે માણસ જીવતો હતો ત્યારે નહોતું કમાતો, એની કરતા મરે છે ત્યારે એટલું દઈને જાય છે. So this is the power of ESIC. So a person, if a workman is covered under ESIC Act, then this would be the benefit. I guess my this slide is not connected. The computer is disconnected. I'm not able to share the slide.
Sridhar bhai, sir, Shivam bhai, sir, I think now
Sir,
you can.
please try again. Please try again.
Okay. There is some internet problem. Please wait. I'm trying to connect it.
It's okay, sir. You can continue with your lecture. We will circulate the PPT after all.
Okay. No, it's just getting it connected. Again, funeral expenses. Now, a person who is a deceased, the legal heirs would be get entitled to get 5,000 as funeral expenses. I mentioned earlier the contribution period. So contribution period is 1st April to 30th September and 1st October to 31st March. So for example, I give you an example that a person is earning 21,000 in Jan. His increment has taken place and in February he is earning 22,000. Then he'll have to contribute till 31st of March, and thereafter only he can exclude it. In one of the my client's company, what they did was when there was an increment, they directly stopped contributing in ESIC. So C18 ad hoc notice came to them, and thereafter that amount was they were made to pay that amount as well as the interest and damages. So again, this is an important aspect. If a person has move above the wage ceiling in any of the month, but the contribution period is to be taken care. So a person has to contribute till 31st March. Benefit period. If a person joined insurable employment for the first time, say on 5th January, his first contribution period will be from 5th January to 31st March, and his corresponding first benefit will be from 5th October to 31st December. Membership. Here there is a mistake. If any insured person wages becomes more than 21,000, it's not 15,000. Earlier it was 15,000 per month. Then she remains covered till the end of the contribution period, as I said. So, which are to be considered as wages in this? See, normally every amount that is we should consider gross amount for calculation of ESI. Actually, what right now prevails is some of the company does contribute ESI on some of the allowances, and some of the allowances they leave it, but that is not to be done. For example, overtime. So many of the company employees overtime ESIC on overtime is not paid, so that cannot be done. ESIC on overtime is also to be paid. So these are the list. I'm not going to into. I'm not reading that. See, this is the main point. Employees Compensation Act not applicable where ESI Act is applicable. So if a person is earning 21 more than 21,000, ESI is applicable to that establishment, but that person is not coming under the wage ceiling. So in that case, employee compensation would apply. But if a person is below 21,000, earning below 21,000, and below 21,000, then he would not be liable to get any benefit from Employee Compensation Act. Benefits of are more than any other act. In one of my client's company, what my client did was he had employed one of his relative who was not suffering. He was suffering from many ailments. He had employed for part time. That person used to come part time. Amount as wages was paid to him. Contribution towards ESIC was given. That person many of the times did not come to the employment. For example, you can say that a person in a month only came for seven days or 2 days or 3 days. But as ESIC was deducted from his account, the bypass surgery was totally done for free of charge, and the expenses was borne by the ESI hospitals. So again, this benefit employee would be getting, whereas in no Employee Compensation Act, this benefit would not be getting. Registration within 10 days. Now, since 2019, they have started one thing. There were n number of illegitimate benefits taken by the company. As in, a person who is not registered, if he meets with an accident, he would be registered on a later stage, and he will claim benefits. The company would claim benefits for that particular employee or insured person. Now, ESIF has come up in 2019 with one thing. When an employee is employed, within 10 days from his employment, he is to be registered. If he is not registered within 10 days, then by giving an application in the format prescribed by the ESIC, only then when it is approved by the ESIC, the person can be registered. So, say for example, if a person is not registered and if he meets with an accident, whether he would be getting benefits under the ESIC Act? Yes, he would be getting subject to the bona fide is shown that because of such and such reasons, registration could not be done within 10 days. In one of my clients' company, what had happened was employees, the workman was of contractor. The contractor did register other employees, but he failed to register the particular employee who met with an accident within 10 days of the time limit. Now, if that contractor would register that person on 11th day, whether ESI would allow that? No, ESI would not allow that. But for that, application is to be made that why within 10 days the IP was the workman was not registered. If they find it appropriate and bona fide, they would definitely pass on the benefits to the employee. So again, if a person who is not registered, it is not that he will not be getting benefit, but only that bona fide actions have to be proved from our side, that is the company's side, to get the benefit of ESIC. I would like to mention the flow chart of cases. Most probably, in many of the your clients' companies, of my client companies, this cases would be coming up. That is, contribution, if not paid, C18 ad hoc notice would be issued from the ESIC, wherein assistant director would be uh, checking the dues and getting the dues corrected or assessed. Before that, the SSO, that is Social Security Officer, would visit our inspection would be done, who would be visiting our premises, and thereafter he would be assessing the dues, whether the payment is made appropriately or not, or whether the amount or the contribution toward ESA is not skipped by the employer or not. So in that cases, C18 ad hoc notice is issued by the assistant director. Thereafter, if we are not satisfied that with that C18 ad hoc notice, then we have option to go on 45AA, that is the deputy director of that ESI corporation. Again, to go to the ESIC, to go before ESIC authority under 45A, 50% of the total SS amount is to be deposited, which is on a very higher side. So after that, 45A order, if we are not satisfied with, we can go to the EI court and thereafter to High Court and Supreme Court. Right? In case of a medical benefit is not extended, then then employee can make a claim. Employee, not employer. Employee can make a claim to the EI, the assistant director, and thereafter, if that is not done, if the claim is not satisfied or it is not responded with within stipulated time period, then that can be traveled to EI court. Now, EPF, Employees Provident Fund and Miscellaneous Provision Act. The major expenses of a company would be in EPF only, because a person who is earning basic as well as DA less than 15,000 would be covered under the EPF Act. Now, a person who is earning less than 15,000 will have to pay 12% from his pocket, and employer will have to pay 12% from his pocket. What actual scenario right now going on is total 50% of the gross is taken in the basic. Other are allowances in which PF is not contributed. So whether that is an accurate practice or not, whether that is allowed by law, as per the recent Supreme Court judgment, not recent but in 2020, Supreme Court gave a judgment that PF is to be paid on each and every allowances, only on that allowances where the allowances are not paid to them. You can say equivalently to each and every employee, as in it is not, for example, if a person, a workman who is getting 20,000 salary as a gross, if he's earning basic less than 15,000, that is 14,000, and other allowances are given, as in uniform allowance is given, or any other allowance such as medical allowance is given. If uniformity of if that allowances is given to each and every employee, then the Supreme Court said that that allowance is only given just to avoid the EPF contribution. So EPF contribution on that is to be paid for on compulsion basis, and that cannot be skipped. Only HRA is a component in which EPF is not attracted. So If a person is earning, for say, for example, 15,000, if 10,000 is given on basic and 5,000 is given on HRA, then then that will be accurate. And on 5,000, no EPF contribution is to be paid. Before that, applicability of this act: a company who is employing more than 20 persons is directly liable for EPF and MP Act registration. But what if if a company is not employing more than 20%? Say, for example, if a company is employing 10%, if they want to take coverage under this act, then they are allowed to take on the voluntary basis. In regular circumstances, when the act is taken, when the 20 employees are exceeded, 12% contribution is to be deducted from the employer side, whereas 12% is to be deducted from the employee side. In voluntary, 10% is to be deducted and not 12%. 10% from employer and 10% from employee. Where this voluntary would work. Say, for example, if your client is a contractor, then if he wants to participate in the tender, then he'll have to take ESI as well as PF number registrations, because it is a tender condition to take. And if that number is not there, they would not allow the tender. They would not allow to fill up the tender. So in that circumstances, what they should do is they should take coverage under EPF Act on voluntary basis. So the 2% is also saved from each of the parties, that is employees as well as employers. And moreover, apart from that, coverage is also done. Benefits: employee covered enjoy a benefit of social security in the form of an unattachable and unwithdrawable, except in several restricted circumstances like buying house, marriage, education, etc. Financial nest, example, to which employees and employers contribute equally throughout the covered person employment. See, this in this EPF account, on last financial year, 8.1% interest was given to the EPF members, and cumulatively, if interest is calculated, then it would be far more than 8.1%. So here, my suggestion would be a person who is employing, who is getting employed, can also make an voluntarily registration to EPF. I'm talking of the member and not the employer. So member can ask the employer to voluntarily register him for EPF and deduct the wages of EPF. So here, what will happen is the employer would be liable to get liable to pay amount up to 15,000 of contribution. That is 15,000, 12% of 15,000, and the employer can increase the amount from 15,000 to 20,000 also. So a person can deduct the contribution on the basis on the 20,000, 12% of the 20,000. So his EPF account will be credited accordingly. So the amount in EPF would be so much that at the time of retirement he can utilize this amount, or he can utilize this amount at the time of buying house, if there is any marriage function or education loan is to be required to be taken. In that, EPF also provides for a advance or a loan by which the amount which is in our account, half of the amount or the amount which is prescribed in the act is taken from given from them from our account. As such, the total amount of the PF is payable normally on retirement or death. Before that, only partial withdrawal can be made, and the total amount cannot be withdrawn. And moreover, one important aspect is also that after an employee has exited the employment, after 2 months of that date of exit is poured by the employer, after 2 months only he can apply for total withdrawal of the amount, not before that. And say, for example, within that 2 months, he has already joined other establishment where where there is a where that establishment is covered under the PF, then his account would be transferred from a previous employer to the current employer. Payment of contribution. I've already explained. I'm not going to that. Rate of contribution is explained. Employer 12% and 12%. Voluntary coverage 10%, 10%. Now, what are the major cases of PF? Major cases of PF provident fund are employers have not paid provident fund as per on the basis of gross amount, or say some of the allowances has been excluded for payment of contribution towards the provident fund. In that case, or in some of the cases, they have totally excluded to pay. They have deducted the amount from the employer, from the employee, but they have not paid the amount. In that case, 7 inspection is done. Thereafter, 7A notices are issued, and thereafter 7A determination of the amount is done. And after determination is done, which at the most is always in the favor of the EPF department, because in that, unfortunately, the government, the adjudicating authority is itself the employee of the EPF. So in that, in most of the cases, the assessment is done on the basis of the balance sheet provided by us. And if you have not provided the explanation with regards to the excluded employees, that is the person earning more than 15,000, in that circumstances, they would be directly taking that 15,000, the person who are excluded, and on the basis, determination of the amount will be done. And that will be a hefty amount. See, the amount may be hefty, but again, if that amount is not disputed or that amount is not challenged, again, what will follow is interest and damages. Interest and damages, see, here I've mentioned what are the damages. If there is a delay in depositing the contribution of 0 to 2 months, 5% per annum damages are levied. In case of 2 to 4 months, 10% is levied. In case of 4 to 6, 15%, and in case of more than 6, 25% per annum damages are levied. So that amount will be very hefty. And thereafter, what will happen is that amount, if levied, that will have to be compulsory paid by the employer. And if employer fails to pay, their bank account would be detached or freezed. And that circumstances, they will not be able to make their further transactions, and they will not be able to make to run their business. So it is always preferable to give each and every documents asked by the inspection, by the enforcement officer who has come for inspection, or when 7A's matter is going on. Every document is to be provided to the adjudicating authority. If that is not provided, then the authority may file an prosecution with regards to non-submission of the documents. And again, for that, there is a various penalties. The penalty is levied, as well as imprisonment is also levied. Now, coming to day-to-day affairs. Now, regarding inspections, right now, inspections of ESI, say it may be of labor inspection, it may be of provident fund inspection. All the inspection now are coming from the Shram Suvidha portal. So it is not that the officer, for example, enforcement officer of provident fund will come to our premises and say, well, there is an inspection and show me the documents. Now they cannot say, because now every inspection is provided by the Shram Suvidha portal. And from that, mail to the authorized representative or the email address given by the employer or registered at the time of registration is on that email address, inspection notice would come from the Shram Suvidha portal itself, and not from anywhere else. So now there is one relief from the government, that is the inspectors, or say enforcement officers, social security officers, labor inspector, factory inspector, would directly come to the factory or the establishment and ask for the records. And if not given, they will ask for some under the table amount. So now this has been stopped. So now inspections are only on the basis of Shram Suvidha portal. When there is an inspection, one can definitely ask them where the inspection has come from and why the inspection has come from, why the inspection has been provided from the Shram Suvidha portal. See, they are bound to give answers. That is, the officers are bound to give answers on what aspect the inspections are formulated from the Shram Suvidha portal. On the basis of that answer given by the officers, only that documents are to be produced, not every. See, it is always said what to produce and what not to produce is the best example of an advocacy. So the documents which are not to be produced are produced, and on that basis, there may be chances that hefty or determination of amount takes place, and on that basis, the amount is to be paid. Or if not paid, they would be recovered it from. They would be recovering it from the property of the company, or else from land and the revenue codes. Now, maintenance of registered. I will go. How many register to be maintained? Prima facie, I would say salary register is to be maintained. I-card register is to be maintained. Overtime register is to be maintained. Fines register is to be maintained. These are the primary register which are asked by the inspectors. Leave encashment register is to be maintained. I forgot that. As well as bonus registers are to be maintained. So if these registers are maintained at the time of inspection, if that registers are showed, that will suffice the cause and they will not proceed for any other prosecution. Time duration of registration. For ESIC, as I mentioned earlier, within 10 days from the date of joining, employee or the workman is to be registered. For Provident Fund, it is not the case. In Provident Fund, a person can be registered after 10 years also. But if the person is registered after 10 years, giving the date of employment or date of joining before 10 years, the contribution till the 10 years has to be paid by the employer. If it is not paid, again, the inspection would arrive from the Suvidha portal. Practical aspects, if I talk about, you can very well share this with your clients that how we can do acts so that inspection does not come. First of all, with relate to ESI, PF, EPF, the amount of contribution of, for example, if a employer is contributing, say for example, for PF with regards to 10 employees, there should not be changes in that. In the sense, say, in the next month, there should not, if he's paying for 10 employees, in the next month it could not be 8 employees or 7 employees. If the employees are deducted or they are exited, in that case, directly the inspection would be triggered. As formula has been set by the computerized, formula has been set by the PFO department as well as Shram Suvidha department, that in case of there is fluctuation of contribution with regards to plus or minus 5%, then inspection would be done. So to avoid that, the contribution with respect to such employees which was made in previous month is to be continued in the next month. No inspection would come. There are cases whereby in our company, in our client's company, inspection has not come since 10 years, 5 years, 7 years, just because they are maintaining the standards. They are maintaining the ratio on which contribution is made. Application in case of accident. Now, if there is an accident, what kind of application is to be made? See, if ESI is covered, then as per ESIC Act, accident form is to be filled up. As per Factory Act, within 24 hours, in case of death, it is to be intimated to the factory inspector, and within 48 hours, in case of injury, it is to be intimated to the factory inspector. Even Employee Compensation Act, the authority is to be intimated within 7 days. In that 7 days is there, whereas in Factory Act, 24 hours and 48 hours is there. So in case of any accident, if this intimation is not done, then again this would be a problem with regards to prosecution as well as penalty as well as non-compliance of the sections, and because of which benefits which are, for example, benefits of ESIC, if that accident report is not filed, then he would not be getting the benefits. So to get the benefits, registration, the intimation with regards to accident is to be done within the stipulated time. With this, I would like to end my today's session. I would like to thank each and everyone for patience hearing.
Thank you so much, sir. Payment of Bonus Act, ESI Act, Gratuity Act, EPF Act, what and what not, all other laws you have mentioned, you have said us in detail, and we really appreciate the hard work you have put in for all our members to know about all these laws and importance of it. Sir, AGFTC's drive to give opportunity to young tax professionals and young professionals who are active in legal judiciary practice, so that the members can take the benefit of their knowledge and experts can show their knowledge. So thank you so much, sir. You have given your valuable time and come us on our invitation. Now I request immediate past president of AGFTC, Sri Bharat L. Seth, to give certain words about this lecture. Bharat bhai.
થેન્ક યુ કાર્તિકેયભાઈ. લેબર લો વિશે આપણે ઘણું બધું જાણતા નથી હોતા, કારણ કે આપણે આપણા કાયદાની જ ઇન્ટ્રિકસીમાંથી ઊંચા નથી આવતા. એ લેબર લો વિશે ખૂબ સરસ માહિતી વત્સલભાઈ આપી અને આપણે બધા જ ટેક્સ પ્રોફેશનલને ઉપયોગી નીવડશે એવું હું માનું છું. અને થેન્ક્સ ફોર વત્સલભાઈ એન્ડ થેન્ક્સ ફોર કાર્તિકેય. થેન્ક યુ.
Welcome.
Thank you so much, sir. Now I request Honorable Treasurer of AGFTC, CA Shivam Bhavsar, to give certificate of appreciation to today's honorable faculty. Sir, thank you so much.
Thank you. I'm glad to have it.
For lecture and for a valuable time.
Thank you. In case of there are any questions, then I'll share this PPT in that my email ID as well as my mobile number would be there.
Yes.
Members are free. Members may feel free to contact me any point of time in case of any difficulty.
Definitely, sir. We are going to circulate your PPT, and thank you for again for giving us the PPT, because it is very in detail, so we can keep it as a handbook. With these words, I just want to convey that AGFTC and IT bar is always committed to bring the new topics in form of allied laws, direct taxation, and GST, and to bring new speakers, new young professionals who are active in legal practice, to bring on this platform for the benefit of members. With these words, I am ending today's webinar. Thank you so much.
Thank you very much.